A lot of clients want to know, if I file bankruptcy, will I lose my car? Will the trustee come and take it? Will the creditor come and take it? What will happen? Because transportation is very important, especially here in Arizona where there's not a robust public transportation system. There are some areas where you could get by without a motor vehicle. New York City with their transportation systems and their subways. I think Washington, D.C., the San Francisco Bay Area has great public transportation systems. Here in Arizona, we need a car to get back and forth to work on the times and the schedules that we need. We need a car to get to the hospital and to get to the grocery store and to get to church and to get to school and to get our children to school. I recognize how important it is to have a vehicle. So I will tell you, it's a rare circumstance in cases that I represent that a client has a car taken from them. Now, why could a car be taken from us? Well, if we're not current on the payments to the creditor, if we financed a car, if we borrowed money from a bank and pledged the car as collateral, they have what's called a non-purchase money security interest. That means they have an interest in the property. And that security interest, that agreement that we signed, says if we fail to make payments on the car, what are they going to do? They're going to repossess it. They have the right to do that. If we buy a house and we sign a deed of trust, that deed of trust is going to say, if we don't make the payments on the home, they can foreclose on the home or they can sell the home pursuant to that deed of trust that we sign. So will our clients lose their car? Will our clients lose their house? It depends. Are we current on the payments? The second thing is whether or not there is more equity in the car than what we can protect under the exemption laws. There's another place on this website where we talk about the exemptions under the Arizona exemptions under the state exemption law system. If you have a motor vehicle that's worth $10,000, I'm sorry, wrong example, that's worth $6,000 and you owe $10,000 on it, there's more owed on it than what it's worth. Therefore, it's considered over-encumbered and the trustee will abandon that asset from the bankruptcy estate. Now, let's use the same car, but we don't owe any money on it. If we have a $6,000 car and it's free and clear, that means we have $6,000 worth of equity. We can protect in Arizona, under Arizona laws, a motor vehicle worth up to $6,000. So it's totally protected. That's whether we file for bankruptcy or not. A creditor cannot come and take that car that's worth the amount of the exemption or less. Now, if the car were worth $8,000 and we could exempt $6,000, then that means there's $2,000 non-exempt equity. Yes, we could lose a vehicle, but we usually don't. What we do is we negotiate with that Chapter 7 trustee to try to maintain that vehicle by paying the $2,000 equity out to the trustee. He puts it in the bankruptcy estate and uses the money to distribute out to your creditors. There's another example, however, and that's where there's a lot of non-exempt equity. Let's say we have an $18,000 car and we can exempt $6,000. That leaves $12,000 non-exempt equity hanging out there. What we will usually do in that scenario to protect this car that we need to get to school, to work, to the hospital, to the grocery store, and to church in, is that we'll file a Chapter 13 bankruptcy if it makes sense, because nobody comes and takes any assets in a Chapter 13. We simply reimburse or pay the creditors through the 36 to 60 month Chapter 13 plan the dollar amount that they would have received had there been a Chapter 7 liquidation of that asset. So the answer is we usually don't lose cars. Now, there are cars that we voluntarily surrender. They're just too expensive for us. The economy has changed. The Great Recession is still going on. We've lost a job, lost our overtime. We don't have that second part-time job anymore. We can't afford a $475 a month vehicle payment on a $26,000 car. If you file a bankruptcy, you can discharge the liability on that car, surrender the car back, and they can't come back after you at all. They can't repossess anything. They can't try to sue you and get a judgment. That bankruptcy discharge has protected you, and you've shed off that extra debt that you have of the $475 a month that you need to help take care of your family's finances. If you really think about it, you can get a car out there for a couple $1,000. Well, that's only 4 months worth of those payments. You could save up, borrow a car from someone for a short period of time, save up, buy a $2,000 car and keep it on the road until you can save up to buy a better car. So if you're current on your payments, if you don't have too much equity in your vehicle, in other words, non-exempt equity in your vehicle, and thirdly, if the vehicle is not just too expensive to afford for you anymore, then the answer to this question is yes, you can keep your motor vehicle, and no, you will not lose your motor vehicle if you file a bankruptcy proceeding.